Boy, Ralph, I don't know about you, but I am super excited about our guest today.
I am too, Yvonne. I am a fan. I just can't help myself because when you talk Florida workers' comp history, our guest lives it and breathes it and writes about it. So, how lucky are we to talk to him today?
He sure does. So, folks, our guest today is none other than Judge David Langham, and he is a prolific writer, blogger, speaker, and we are so lucky to talk to him today to do a brief history and summary of the Florida workers' compensation system. It's really interesting. I always enjoy talking to him.
Me too. He makes it fun, he makes it exciting. And I just learn from listening to him. He has such an incredible mind for it. And you can tell he's a teacher and a writer at heart because every time we speak with him, he shows us that.
And loves history, like we talked about, like we always talk about. We love history. We love digging deep and figuring out why things are the way they are. He's like that. And so, yeah, he's just, anyway, let's get on to talking to David Langham and learning about the Florida workers' compensation system. So today we are talking about the Florida workers' compensation systems. And so you agreed today to talk about the Florida workers' comp system. So the idea is we only have about 35 minutes. We want to talk about what's important and different about Florida. What is it that's worth noticing? That we talk about how we have these nuances and differences between the 50 different state systems. So I'm going to turn it over to you and let you start talking about Florida workers' comp.
Well, I think the most apt description of our system, and it's not mine, but I won't throw anybody under the bus. But the most apt description is that we have literally tried everything that doesn't work in Florida at some point. Um, we've we've had a legislative history that I think rivals any place in the country. Yvonne, we really went through a tumultuous period, but historically we started with an industrial commission back in 1935. And that survived as a leadership model with the folks in charge being non-lawyers for the most part, folks appointed for their bias and prejudice. They were specifically intended to be prejudiced. So somebody had to be on the employee side, somebody had to be on the employer side, then there was a chair that was sort of unbiased. It was designed to be confrontational. We evolved from that as administrative law started to take hold in the country. And in 1968, we abolished the Florida Industrial Commission, and we founded the Department of Commerce in the executive branch, and they stuck the workers' comp system into that. But the old commissioners had heard appeals, and we didn't want administrative folks hearing appeals, so they created a uh, Industrial Relations Commission, an IRC, to hear the appeals from the judges. And that went on for about 10 years till 79. We got rid of the IRC and the appeals went to our Florida First District Court of Appeal, and that's where they've been ever since. Interesting tidbit, the day they moved our appellate process from the IRC to the First District Court of Appeal, that made our Florida First District Court of Appeal the second busiest appellate court in the country in
Wow.
terms of case count. Back then, workers' comp was generating about 2,000 plus appeals per year. Now it's about 250. So a lot's changed in terms of predictability, transparency, etc. We had a lot of challenges. 1974, the National Commission came out and said comp's not very good and it could be better. They made a lot of recommendations. Your state legislature in Florida reacted to that and ramped up employee benefits in 74. Came around in 79 after the Pappy Commission did their study and ramped it up even more. We took our detour into what we called wage loss that was somewhat disastrous from both the lawyer's perspective and the injured worker's perspective. That went along till about 1990, and then we had an 89 law, a 90 law, a 91 law, a 94 law, and Rafael and I have talked about this many times. The tail on a workers' comp claim, if you think about somebody getting hurt, by the time they get medical care, by the time they can reach a point of stability, that's going to take longer than a year most of the time. Okay, not for a cut finger, but for a herniated disc, for example, or a blown knee. we were changing the law so rapidly, we never were seeing what the effect of the last change really was before we made the next change. So the legislation process was frenzied, if you will. In 93, we made a big change in the special session, and Florida stepped out in front. One of our great contributions to workers' comp was 1993 in the special session. We were the first state in the union to mandate mediation of all claims. And so that's been the law since 1994. Other states have tried it. They do voluntary mediation. Some have followed us into the mandatory, but we've really believed in alternative dispute resolution all along. And you talk about things that make us different. I think that really makes us different. We think there is not a claim that doesn't deserve to be talked about. And so even if we're going to get to an impasse, we're going to make the parties sit down and talk about it first. And I think that's really huge in terms of getting people out of their shell and getting communication going and helping people feel like they're part of the process. Along we go until, well, another of the big mistakes that year was managed care. We tried to force everybody into managed care. That lasted until about 97. We pulled back on that. What we do in Florida that's also unique since 1994, Yvonne, and you say this at a national conference and half the room will cringe and the other half picks up things to throw at me. But here, the employer picks the doctor in 99% of the cases. So if you get hurt in other jurisdictions, there's a good chance the employee's picking the doctor. Which of those is the right solution? Well, here's the problem. The employer and the employee both have an interest in this workers' comp case, and we can argue that the employee's is more profound. But at the end of the day, the employers don't trust the doctors picked by the claimant, and the claimants don't trust the doctors picked by the employer. There is no solution where everybody's going to have full trust. So some states have gone to a bifurcated method where the employer picks a panel of 3 and the claimant gets to pick off of that panel. That's sort of a middle ground. We tried that for a couple of years. It really created more challenges and more delays than it did solutions. So we're now an employer selection state. So that's very unique here. Lack of doctors has been a big problem in Florida, really dating back to the 90s, but it's getting worse. We're way, way underpopulated with physicians in Florida. Way too many doctors are being pulled off from the medical school graduate groups into medical research. I'm not saying we shouldn't be doing medical research, but 30 years ago, a lot of those people were going into orthopedics, right? They were going into neurology, and we need those doctors to treat our injured workers. Medical research is pulling a lot of folks into orthopedic devices and medication and these other wonderful things, but it's leaving a deficit for us in the boots on the ground department. We've got places in Florida you might wait 90 days to get in to see a specialist physician. That's really troublesome, particularly if you're the person that's hurt. You'd like to get in and see somebody. We're leveraging our medicine a lot in Florida, so a physician can oversee more than 5 paraprofessionals. I'm not positive of the number. I believe it may be up to 10 now. So a lot of injured workers are going to the doctor's office and they're seeing somebody in a white coat and they're getting their treatment and their prescription or their recommendation. And then they're sort of nonplussed when they find out later that that was a physician's assistant or a nurse practitioner. There's nothing wrong with those folks, but the claimants are feeling like they weren't entirely honest with. That they should have sort of been told, you know, I'm here working for Dr. So-and-so, and I'm going to do this, this, and this, and she's going to do this, that, and the other. And they, for whatever reason, don't feel like they're getting that communication. In fairness to the medical professionals, it's my experience that sometimes folks who are injured and suffering from pain or other symptoms aren't as good at remembering things as perhaps they might be if they weren't in distress. And so some of those things may be said to those patients, but they're not remembering it. And so that's just a communication challenge that we have. So you move forward to 2003. Probably the other biggest unique thing, and I met Yvonne through David DiPaolo years ago. David DiPaolo went absolutely nuts when he found out that in Florida we have a prevailing party cost provision. And we're not the only state, but I'm pretty sure we were the first state. And somebody out there listening will say, oh, no, we've had that since, 1911. Yeah, you did, but your prevailing party cost statute said that if the claimant prevailed, they can get costs of the litigation from the employer. Ours just says prevailing party. And so now that injured worker, Yvonne, who's seeking knee surgery or is seeking indemnity benefits, if they file that claim and they don't prevail, then the insurance company may be able to ask for their litigation costs back from that injured worker. And some of those injured workers, frankly, probably have the resources to pay it. Let's be real. People get hurt that make $1 million a year. But a lot of people get hurt that don't make near that kind of money. They're making minimum wage or they're making a workman's wage, and they don't have $8, $10, $12,000 to pay somebody's litigation expenses. So that's reasonably unique. What's not unique about Florida, back to the medicine, is the rising cost. You probably don't notice it, but I go to the grocery store, and for some reason, every time I go, I've found, you'll never hear this my whole life growing up, as I've gotten older, honest to goodness, I've gotten stronger and stronger and stronger. Okay. Almost a Superman capacity. When 10 years ago, I'd go to the grocery store and buy $100 worth of groceries. It took 4 trips to carry it into the kitchen. I can get it in one load now. And my hands don't even hurt on the bags. I can carry $100 worth of groceries. It's like nothing to me.
That is true.
What people need to think about is that's not true just in groceries or televisions or automobiles. The medical spend in Florida is up somewhere north of 70% now. When Rafael and I got into this business, it used to be about 50-50 benefit dollar going to indemnity in the claimant's pocket and medical. And now it's north of 70% going to the medical professionals, the hospitals. I'm not saying there's anything wrong with that. I'm saying it's not keeping a pace with the person that's injured getting a recompense for their time off of work or their disability or impairment, depending on how you measure things at the end of the case. So those things are affecting us. I think that over the last 8 years, we've had nothing but rate decreases. Frequency continues to decrease across the state. Severity seems to continue to decrease across the state. And the medical costs keep going up. Why? It's pretty simple. It's not calculus. Uh, the medical profession keeps coming up with amazing stuff that they can do. If I was on this recording back when you started 10 years ago and I said there are doctors that are hand making silver bullet pills to treat people's cancer, and they people go to the hospital and get their DNA drawn, and these doctors build a pill and it kills their cancer, you'd have laughed at me. But that's real today, right? But all of that requires research development. It requires money. And so those kinds of things, I think, are driving up the cost of medical care. We can do all these fantastic, wonderful things, but they all cost money. Um, how would we fix that? I don't know. I think we probably need to be putting some more money back into our system. But at this point, we're pretty happy with the decreasing rates and the expense ratio. Workers' comp carriers actually can make money in Florida. And that's not always been true. You go back to when we started the conversation, back to 74, 79. Our system was in crisis back there. Carriers couldn't make money. Carriers were leaving the state. Um, Talk about things that we tried here first. We were among the first states to really have a blossoming and blooming self-insurance market.
Mm,
That wasn't because everybody thought self-insurance was such a great idea. It's because the carriers weren't here to write the coverage.
mm,
They wouldn't take Florida risk. And so you had groups like the Florida Construction Group that started self-insuring. That's called FCCI insurance now. We evolved through big self-insured times into back to an era now when carriers are reasonably happy doing business in the state of Florida, even though those premiums are going down. So So what's challenging about our system right now, I think, is not unique to Florida. I think our biggest challenge right now is the lack of community. We're struggling with everything being too remote, too much virtual. Folks are not getting into the office. I just wrote a blog post recently about the CEO of J.P. Morgan and his complaint that young people are being sort of cheated by the virtual work environment.
Mm.
It's not so much a big deal for old folks to be alone at home working, but for young folks, the lack of collegiality and the lack of interaction and spontaneity is sort of damaging to them. Um, I'd like to see young folks getting out more often, and I'd like to see us having more opportunities like we used to have back when you all did the awards program, and now we're down to just sort of a couple things we do every year that folks come to in large numbers in person. We need more of that. Um, we've got a great debate going on in Florida now about what we call stare decisis. So from
Sorry, decisis. Is that what you said?
yeah, from back in the common law and after the Norman Conquest in 1066, Ralph asked me to go back a little deeper in time. So go back to 1066 and the birth of common law. That was an English system where a judge would make a decision, Yvonne, and the next time the issue came up, you'd refer back and say, well, the judge decided this last time, and you should do it the same way this time. And that afforded a level of predictability, a transparency. And
Mm.
so folks sort of figured out what the habit was regarding this or that under the law, and that gives people some comfort. What's the last thing you want to hear, Yvonne, if you go and hire Raphael to be your lawyer and you tell him your problem? The last words you want to hear are, I don't know,
Exactly.
or
I don't know what's going to happen.
yeah, it depends. You want an answer. Even if
Hmm.
it's not, you're going to get this much money, you're going to get somewhere between this, and here's how it's going to work. Well, we've got now sort of a battle going on for our soul. There are those who think that every question should cause us to go back and look at the statute fresh, and it is a statutory system. Others think you should be able to rely upon what the First District Court of Appeals said last time this issue came up.
Mm.
And that's sort of being bantered about right now with our statute of limitations, which has been in place for 30 years. But sort of out of the blue, we had the Ortiz versus Winn-Dixie case here about 2.5, 3 years ago. And it came up with a new interpretation of what that statute means. Now, they've since withdrawn that opinion, but it still sort of livens up the audience. Um, those things are challenging because the adjuster wants to know, how's this going to come out? The injured worker, when they go and hire a lawyer, they want to know how this is going to come out. So we're sort of balancing between the predictability and between the truth to the statute. And I think that's going to take us several more years to sort of sort through. So that's a problematic challenge for us. The last thing I would say about Florida that is different, I think, not unique, but for some reason, people just want to keep coming here. And so our state is growing at not the rate that Texas is, but not far off from it.
Hmm.
And you look at Texas, if you superimpose the outline of Texas on Europe, you can see how much land is there. It's a huge state. We're not that huge, and people just keep streaming in. And I
Hmm.
think that's a challenge for us in terms of distracting those doctors, okay, who aren't doing medical research, but now they're treating old people that have knee injuries, right, or knee problems, and there's less doctor to go around for the person that injures their knee at work. So all this immigration, I think, is creating a demand on our systems and our processes that's going to make workers' comp a little more difficult in coming years till we get our doctor populations sort of pulled up to meet that demand mark. So that's sort of in a nutshell what I think about workers' comp or what I think is important about it. But in fairness, Raphael's been doing this. He'd been practicing 30 years when I got out of grade school. So he knows a lot more about this than I do. In fairness, I mean, right? No.
Well, I just before we unleash Raphael, I want to ask a couple of things just to sort of clarify the conversation a little bit. So When you say immigration, you mean people moving from other states coming into the state, not specifically, people coming from out of the country and just people moving around.
Well, but we have people from out of the country too. It's just the fact that our population's growing,
Right.
and a lot of it. You talked earlier about retiring. A lot of people have dreamed their whole life of retiring in Florida, and I'm glad they're coming. But they tend to be a population that needs a level of medical care,
Right.
and so that's pulling off resources that we could have treating the injured worker because we're treating the older folks, the
Well, that's
retirees,
what I was going to say. The issue you're talking about, and yes, we have it. It's a pretty severe issue here in Florida, but it's sort of like in our entire healthcare system. It's a big problem in California as well. There's a huge shortage of doctors. So I don't think that's necessarily unique to Florida, but I take your point is well taken. It is exacerbated in Florida due to a few situations that are happening.
Yeah, and it's going to be a challenge.
Mm-hmm. Okay, Rafael, I see that you've been taking notes.
I always love and enjoy listening to and learning from Judge Langham. And it really is, David. It's really amazing. I know that, there's probably no one in the entire country in our system that has written so much about the workers' compensation system that you have. It really, you amaze us all in the volume of work that you continue to put out and have been putting out for years. It's really incredible, including, I want you to tell the folks, you've written a couple of books here, and you've recently published, I think another book here. Tell us, is it about the history of Florida workers' comp?
Yeah, well, and believe it or not, because of the ethical rules, I can't discuss all of my books. But my history book I published last August, and it's titled Floridiana and the Workers' Comp Adjudicator, and that's available on my website, and it's a free download. It's about 250 pages, I believe. And I literally did. I started back at the end of the Ice Age, trying to explain why this place is so different. Florida's a weird state. It always has been. And that goes back literally to the land mass and the climate and all of these things sort of coinciding to make us a unique spot. But part of that, I traced all of the folks that have ever adjudicated full time, had the job of being a workers' comp judge in Florida, and prepared a little bio on each of them. We've got about almost 300 of them. And I think we're the only system in the country that's documented all of their participants in that way. The other book I'm working on now, we're going to probably release in the fall, is a trial primer for young lawyers, where we're trying to bridge that gap. Over the last several years, we've not had a lot of new young folks coming into comp, and as a result, today we've got a lot of really young comp lawyers and a lot of people in my age group, which we won't describe, but we're really old. That's the only fair way
Tenured.
to say it.
We're tenured.
Well, so I put that together to just try to provide a resource for those people, and we're going to publish that also free, so that those folks can download and hopefully have some tips and pointers on how you try a lawsuit. Why? Because not many people are trying lawsuits. Appeals are down, trials are down. Settlement is the name of the game in Florida right now. And so if you needed to go to trial, unfortunately, the populations we used to have just aren't there anymore. The Ray Malkas are retiring. You mentioned George Kagan, Jerry Rosenthal. These folks that used to try cases, they're just not doing it anymore. And the young folks are sort of left on their own. So that's been enjoyable.
Well, I wanted to also, you said that you met me through David DiPaolo, which we certainly got to know each other better through David, but we knew each other before that. I've been in the Florida workers' comp system as long as you two have. Just was behind the scenes.
And we met?
Yeah.
Okay.
Well, I've been going to WCI forever. You just didn't know me. I was quiet and reserved and shy, if you can believe that.
I don't remember meeting you until David introduced us.
Yeah, we met. We definitely got to know each other through David and the Comp Loudy work that we did. Anyway,
My
I'll see if
my
I can find a
recollection
record of it, but
my recollection was him hooking you by the elbow at the WCI. We were standing talking about something, and you
mhm.
were walking past, and I would guess that's got to have been 15 years ago.
No, it was about 10, 11 years ago.
Okay.
'Cause he
Yeah.
passed away in 2016. Anyway, we don't have to do a history lesson on how long you and I have known each other, but I'm pretty sure. I mean, let me put it this way: I knew who you were. I would come and watch you talk, like Raphael said. You've
That
been
could be
lecturing and
good. It could
writing
be
for years and
bad.
years.
It could be good or bad. It
And
could.
so I would come and listen to you, but you probably didn't know who I was, so that's all right. It's fair.
Well, the crazy thing about this system is it's got so many moving parts and people involved and engaged in it. And one of the complaints I hear is that there's a lack of comprehension. People that do medical bill repricing don't really understand the medical piece. The people that do the actual treatment don't necessarily understand the adjusting piece.
Right.
You know, and so we've got what I call silos of expertise, and they sort of meet at places like WCI or the forum, but they don't really understand what each other does and how they bring value to the system and what the process would look like if any of the silos quit working.
Well, that's part of what we hope to do here after we get through the history and sort of talking about some of the key, um, specific things to know about the system. That's the rest of the time we'll be talking to different stakeholders and talk to them about their role and what is the role, what is the defense attorney perspective, what is the employer perspective, what is the carrier perspective. And so that's the thing when you really boil it down. When Raphael and I were planning, we were like, wow, no wonder nobody can understand what the heck's going on, because it really is complex.
Yeah. And half of us don't speak each other's language.
That is true.
You know, they're they're all comfortable in their silo and they speak to each other in ways they understand, and I don't think we appreciate each other.
That is true. And that is one thing, to bring David up again, that I just remember that very clearly about him. And one of his reasons for starting the Comp Audio Awards was to deal with just that. He used to say, if we could just get all the stakeholders in a room for a day and just get to know each other and get to know each other on a personal level, it would make the system so much better. And I
And
think he was right.
it worked. The problem was that he went off and died on us.
Mm.
Rascal.
Yeah,
Well,
I
Ralph,
don't
I
know.
want to ask you, because you know what we're trying to do here with it was a fascinating history lesson, David. Thank you so much. But are there anything specific? Is there anything specific you think we want David to explain to us from the judge's seat, since we have him? I mean, again, we're so lucky to have you today.
Judge, lots of states around the country have used medical guidelines, pharmacy methodologies, right? Also to try and either bring that consistency and cost down. Florida has never gone down that road. Give us your perspective on why Florida has never, looked at those or ever adopted any of that.
Well, I think the primary driver, frankly, is that those things have come to fruition or to popularity in the last 15, 20 years. And we haven't had a statutory revision since 2003 that was of any real meaning. You could argue about a couple of little things that got adjusted, but for the most part, no real revisions. Our legislature historically has only been interested in working on workers' comp when it gets the system into crisis. And we're not in crisis. Rates are down, insurance is available. For the most part, the system constituents are reasonably happy with the way it's working. And so I don't think the legislature is inclined to go in and try to fix something. The phrase that's been said to me is that that's a solution in search of a problem. And we do that. We hear that when we talk about guidelines, when we talk about things like IMR or the potential for quicker resolutions. How that will change, I think the medical inflation is going to keep pushing, and as it does, that's going to become problematic for rates. And when the rates turn, they may very well look for those solutions. Um, The derogation you hear about treatment guidelines is that it's cookbook medicine and that patients should be treated as individuals and respected for who they are and not reduced to a diagnosis. And I see some merit in that, but I also see the argument for much more rapid deployment of medical resources where the doctor's not having to ask permission for X, Y, and Z because they're listed as normal treatments for this diagnosis. Um, so I can see both ways, but as you say, we have not seen our legislature become interested in adopting those.
The last thing, just recently, right, a member of the Florida legislature put in a bill to give us sort of what Texas has had here for a while, which is an opt-out system, if you will, right? Providing injured workers with another system altogether, right? An employer-driven system to provide benefits to that injured worker. Kind of a first, if you will, in our state. I know there have been a couple of states out there who have tried it. Texas certainly, is the one example that's worked well for them. Give us your thoughts on how does that happen here in Florida? How would that look here in Florida? What are the chances anything like that could exist here?
Well, in fairness, Texas never did have an opt-out. Their law is strictly opt-in. So, and Texas is the only state where workers' comp is voluntary. I have this argument many times with my good friend Dave Torrey, who's now retired, a Pennsylvania judge. We have opt-out in Florida. There's opt-out in at least 11 or 12 states. The difference is that in Texas, it's purely voluntary and anybody can choose not to be involved in comp. In Florida, our opt-out is what Judge Torrey refers to as a carve-out, because if you have a union shop, the union and the employer can negotiate to build a alternative system.
Mm.
We're trusting in that model an awful lot in the collective bargaining process, that the union will do a good job, the employer will do a good job in fashioning something that can work and be an effective substitute. I've heard a lot of, no personal experience, but I've heard a lot of compliments about the carve out or opt out that was put in place by the Miami Dolphins. And they had a lot of what I would call the academics of workers' comp in Florida that helped them build and run their system. And it's worked very, very well over the years.
Mm-hmm.
Outside of a collective bargaining agreement, you've got to ask yourself how much negotiating capacity or influence does the injured worker have? And here's where I have the real challenge. I try this in my college class every semester. There's not ever a student that understands workers' comp. When I ask them to raise their hand if they know that workers' comp would cover them in an on-the-job injury, they look at me like I'm crazy. And I say, well, what does that mean? And how does it relate to the tort system? They have no idea. These people are in college. If these young folks who are studying the law aren't cognizant of the way workers' comp works, how on earth are people out in the business world, workaday world, who've got 1,000 widgets to make or 1,000 customers to service or whatever it is? Workers don't know anything about workers' comp until something bad happens,
Right.
right? So if we're going to ask people to opt out, how would we make a valid and knowing decision about opting out when we don't have any foundation? So as an example, let's just say that, Rafael, you work at a law firm. My plan for you is that you sign this piece of paper and it says that that if you end up needing medical care through your group health carrier at your law firm, that all these different things are going to happen the way I designed them to happen. And you might look at that and say, well, you know what? I don't care. I'm not going to get hurt. Let me sign that. Because none of us believe it's going to happen to us, right? And then after it happens, then, oh my goodness, what did I sign? What does that say? That's where I have the challenge with it. If there's a potential to do an opt-out where people are truly informed and can make an academically intelligent decision about what they're giving up and what they're getting, then I'm a free market person. I say let people contract for what they want. But I think that takes an awful lot of disclosure, full disclosure, and everybody needs to go into it with their eyes wide open and know how things might end up, good, bad, or indifferent. So it's a challenge, it really is.
Yeah. As always, man, you're so incredible. You really are. You're amazing at taking these very complex issues and breaking them down into little nibbles that we can all really appreciate and really, understand and bite into. So kudos to you always for doing that for us.
I only can do that because I have to break them into those little bites for me to understand it myself.
Oh,
That's a lot of us. That's exactly, yeah, it's
well,
hard to take these very complex stuff all at once. Yeah.
well, we are aiming to try to keep these episodes shorter this year. So in that line of thinking, I'm going to say it's time to wrap. And David, thank you so much for joining us again. It's always a pleasure talking with you. I don't talk with you nearly enough. And I really appreciate your time
having me.
Yeah, absolutely.
And maybe I'll see you all soon at a real live someplace where we can actually shake hands.
I would like that very much. All right. Until then, as we always say, hasta luego.
There you go.
Be well.